Good morning, this is your Kelso Report for Thursday, October 11th, and I'm your host, Clark Kelso. Our first two cases this morning deal with attorney's fees. In the first case, the Ninth Circuit considers whether the Bureau of Land Management's decision-making was substantially justified, even though erroneous, so that fees should not be awarded under the Equal Access to Justice Act. In our second case, the Second District holds that a law firm represented by its of counsel cannot recover attorney's fees because of counsel is a de facto member of the law firm. Our third case this morning recognizes the right of a juvenile to accept a plea bargain without the consent of his legal counsel. Well, let's get started with our attorney's fees cases. One of the obstacles to gaining access to the courts is the need to pay for your own attorney. Under the so-called American rule, litigants are generally responsible for their own attorney's fees, unless one of several exceptions applies. One of the most important exceptions is where attorney's fees are provided for by statute, and both the federal and state legislatures have enacted literally scores of statutes authorizing the recovery of attorney's fees in particular cases. One such statute enacted by Congress is the Equal Access to Justice Act, the purpose of which is to eliminate for the average person the financial disincentive to challenge unreasonable governmental action. Under the Act, in an action brought by or against the United States, the court must award a fees and costs to the prevailing party, other than the United States, unless the court finds that the position of the United States was substantially justified. Now, because the focus of the Act is on preventing or deterring unreasonable governmental action, fees may not be awarded if the government's position is substantially justified, even though erroneous. You can be reasonable but wrong. In Western Watersheds Project versus Ellis, the district court had denied fees under the Equal Access to Justice Act to the plaintiff after concluding that the government's position was substantially justified, even though the court ruled against the government. The Ninth Circuit agreed. The plaintiffs have been engaged in a decade-long battle with the federal government over the Bureau of Land Management's renewal of grazing permits in large parts of southern Idaho, and the plaintiffs had prevailed at various stages of the litigation. Although the parties believed they had settled the litigation in 2006, a massive fire in the area changed the circumstances, and the Bureau then decided to allow grazing on unburned areas, and then after a period of time renewed granting permits. Well, the plaintiffs successfully challenged the Bureau's post-fire decisions. But because of the fire, the district court concluded the Bureau's post-fire decisions and its decision to litigate those decisions were substantially justified, even though the court had ruled against the Bureau on the merits. As the district court explained, the Bureau was not blatantly disregarding the court's prior decisions. Instead, it was scrambling to salvage something from a natural disaster. And accordingly, the courts denied the plaintiff's request for an attorney's fees award under the Equal Access to Justice Act. Our second case today also involves attorney's fees. As a matter of policy and law, the California Supreme Court has held that a law firm cannot recover attorney's fees when its own partners and associates have represented the law firm in litigation involving the law firm, where the law firm is a party to the litigation. If a firm chooses to represent itself, there is no separate attorney-client relationship, and a separate attorney-client relationship is a premise of attorney fee awards. In addition, the cost of representing oneself, according to the California Supreme Court, is simply a lost opportunity cost that is not recoverable. Well, in Sands and Associates versus Juk-Navorian, the Second District faced the question of whether a law firm that is party to litigation may recover attorney's fees under a prevailing party clause in a contract where the fees were incurred by the law firms of counsel who represented the law firm in the litigation. The answer to this question depended on how the court characterized the of counsel relationship. Is an of counsel an independent lawyer? Or is an of counsel so closely associated with a law firm that it should be considered the equivalent of a partner or associate of the firm? According to the Second District, the relationship between a law firm and of counsel is generally so close, personal, continuous, and regular that a law firm and its of counsel must be treated as constituting a single de facto firm. Given this interpretation, the court held that a law firm cannot recover attorney's fees under a prevailing party clause in a contract when, as a successful litigant, it is represented by its own of counsel. Now we turn to a juvenile court issue. In general, the capacity of minors to make decisions affecting their own lives is pretty limited. Usually the parents are the ones who get to make decisions. For example, the law traditionally has treated minors as incapable of entering into legally binding contracts. Minors are generally not held to the same standard of care and negligence as adults are. Minors do not have capacity to consent to many types of medical treatment, and the list goes on. Yet the law has in recent decades begun to recognize that minors have a legitimate interest in deciding certain things for themselves. And somewhat paradoxically, certain decisions are viewed as too important to deny the minor his or her right to choose. This was the issue before the Third District in Re Alonzo J., where the court had to decide whether a 13-year-old had capacity to accept a plea bargain offer without his legal counsel's consent or approval. The juvenile in the case was charged in a petition under Welfare and Institutions Code, Section 602, with 2 counts of assault with a deadly weapon by means of force likely to produce great bodily injury. The weapon in this case was a skateboard and a small metal heater, and 1 count of malicious damage to a door arising from an argument with his mother. Based on his counsel's recommendation, the juvenile court rejected the juvenile's attempt to accept a prosecution offer to plead to 1 felony count of assault with a deadly weapon with home supervision. The counsel believed that the plea was factually unjustified. Well, following a contested jurisdictional hearing, the juvenile court sustained all 3 charges against the juvenile, continued him as a ward of the court, and directed his placement in either a foster home, group home, residential treatment center, or the home of a relative or friend. The Third District held that the juvenile court erred in preventing the juvenile from accepting the plea offer. As the court noted, in light of legislative changes to the California Rules of Court, and a few court decisions, the law now generally affords juveniles the basic plea rights and protections that it affords adult criminal defendants, assuming those juveniles are, as in this case, capable of understanding and exercising those rights and protections. These changes in the law essentially recognize that the courts should respect a juvenile's personal choice over such a fundamental decision in his or her case as whether to accept a prosecution plea offer. Certainly in this case, the juvenile's decision would have turned out better than his counsel's. And that's it for today's Kelso Report. Have a great day in the law.